Hello, welcome to World News Network. I'm Jennifer Varenchek. Tonight we start with breaking news. The Supreme Court has made their ruling in the United States versus Lopez case. With so many cases coming out of the Supreme Court this session, let's have a refresher about what this case is all about. On March 10, 1992, the respondent, a 12th grade high school student, arrived at Edison High School carrying a concealed .38 caliber handgun and 5 bullets. This is horrifying, right? Well, luckily, there was an anonymous tip, and school authorities confronted the respondent, who admitted to be carrying the concealed weapon. He was arrested and charged under Texas law with firearm possession on school premises. Today, the Supreme Court held that the Gun-Free School Zones Act of 1990 is a violation of the Commerce Clause, and the act exceeds the authority of Congress to regulate commerce among several states. Their words, not mine. To help us with the Supreme Court's analysis, we are going to join our senior legal correspondent, Naomi Miguel, who is live at the Supreme Court. Hello? Naomi? Naomi, can you hear us? Well, folks, it looks like we're having some technical difficulties. Let's take a short break and we will be right back. Joining us live at the Supreme Court is our senior legal correspondent, Naomi Miguel. Naomi?
Hello, Jennifer. I can hear you clear as mud right now.
Oh, good. Now, speaking of mud, can you walk us through the Supreme Court's decision today?
Well, Jennifer, it's quite a complex decision. First, let me take you the procedural history of this case. The district court ruled that the respondent violated the Gun-Free School Zones Act of 1990 and sentenced him to 6 months imprisonment and 2 years supervised release. The Court of Appeals for the Fifth Circuit upheld the district court's ruling and reversed this respondent's conviction.
Why in the world would they do that?
The Circuit Court of Appeals for the Fifth Circuit noted insufficient congressional findings and legislative history within the case and also found that the act is beyond the power of Congress under the Commerce Clause.
Did the Supreme Court go through any legislative analysis of the Commerce Clause?
Actually, the analysis began with a look at the Constitution's creation of the federal government. The court quoted James Madison, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in state governments are numerous and infinite."
Yeah. Founding fathers and all of that. How does this relate to the ruling in this case?
The court began with that quote because it would need to examine the balance between federalism and the Commerce Clause. This foundation will ultimately lead to the question of whether the federal or state government has the power to regulate gun-free school zones.
Okay, so how does the Commerce Clause relate to this?
Article 1, Section 8, Clause 3 of the United States Constitution refers to the Commerce Clause, which gives Congress the power to regulate commerce with foreign nations, among the several states, and with Indian tribes. The 10th Amendment also states that the federal government powers not enumerated in the Constitution are reserved for the states. Does this remind you of the quote from James Madison?
Let's get a move on here, Naomi. I know you would want to turn my show into an hour-long discussion about this case, but I have other segments to get to. So take me to the meat and potatoes of this case.
Well, Jennifer, I would like your viewers to really understand the ruling in this case, so it will take a while to go through. Let's start with the first case the Supreme Court had in relation to the Commerce Clause. Gibson v. Ogden in 1824 held that commerce describes the commercial intercourse between nations and parts of nations in all its branches and is regulated by prescribing rules for carrying out on that intercourse. Taking it a little further, the court proceeded to go through their past cases involving the Commerce Clause. The majority of those cases involved interstate commerce or production, manufacturing, and mining. However, In Wickard v. Filborn, specifically to the topics of production, manufacturing, and mining, the court held those categories were within state powers and beyond the powers of Congress under the Commerce Clause.
Interesting. Are there any other cases after Wickard that the court heard involving the Commerce Clause?
Of course, Jennifer. We know the court wouldn't just stop at Wickard. In NLRB v. Jones and Laughlin Steel Corp., the court upheld the National Labor Relations Act against a Commerce Clause challenge because there was a close and substantial relationship to interstate commerce, and the control is essential to protect that commerce, which is within Congress's power to regulate. Further, in United States v. Darby, which was held in 1941, the court upheld the Fair Labor Standards Act and stated interstate commerce is not confined to the regulation of commerce among states. It extends to those activities intrastate, which also affects interstate commerce, and that power is granted to Congress through the Commerce Clause.
Well, with Wickard, NLRB, and Darby, you would think that the court would have ruled in favor of the Guns-Free Zones Act, if not for precedent, for the mere fact that we should be protecting our children from guns at school.
In the court's analysis, they identified 3 categories of commerce where Congress may regulate their commerce power. First, Congress may regulate the use of channels of interstate commerce. This could be related to transportation of a product or commodity. Second, Congress is empowered to regulate and protect the instrumentalities of interstate commerce or persons or things in interstate commerce, even though the threat may come from intrastate activities. An example of this would be thefts from interstate shipments. Finally, Congress's commerce authority includes the power to regulate those activities having a substantial relation to interstate commerce.
Okay, so the U.S. v. Lopez case is not a regulation of the use of channels. It's not theft from shipment, and that leaves us with the last category, power to regulate those having a substantial relation to interstate commerce.
Exactly, Jennifer. The court began its analysis of that last category by acknowledging they have upheld congressional acts regulating interstate economic activity in the past, since it substantially affected the interstate commerce. Some examples they provided involved credit transactions, restaurants utilizing substantial interstate supplies, and inns and hotels catering to interstate guests. The interesting part is that when the court related the economic impact of the commerce into its analysis of this category, the court noted that when it reaches far in relation to the Commerce Clause, the authority involved some type of economic activity, which is missing in the United States versus Lopez case.
This is all very interesting. What did the government have to say in response to the last category?
The government claimed that the firearm possession substantially affected interstate commerce and the national economy in 2 ways. First, the costs of violent crimes are substantial when you think of the insurance or costs involved in violent crimes, especially ones with firearms. Second, violent crimes reduces the average citizen's motivation to travel interstate, thus affecting the economy. Further, the government noted that the firearms in schools would distract from education and create an unsafe learning environment. The court acknowledged the government's argument, but noted that areas such as law enforcement or education is usually within the state's power. Since there is no economic activity linked to the Gun-Free School Zone Act, the court held that the act failed to meet any of the 3 categories of commerce where Congress may regulate the commerce power.
Well, now that we have the court's analysis down, I would like to bring in the principal of Edison High School, Mr. Jermaine Alexander.
Hello, Jennifer. Thank you for allowing me to speak on your show.
Mr. Alexander, thank you for joining us.
Thank you.
Mr. Alexander, thank you for joining us. We're examining the Supreme Court case, which began at your high school, Edison High School. Today, the court ruled that the Gun-Free School Zones Act of 1990 exceeds the authority of Congress, therefore eliminating gun-free school zones. Being the principal at high school where this occurred, what is your reaction to this?
Well, Jennifer, like everyone else in the education community, we are appalled at the court's decision today.
Why is that, Mr. Alexander?
I interpreted the Commerce Clause to mean that Congress has the power to regulate commerce, which includes local activities that affect interstate commerce. Guns near our schools is a local activity that affects our interstate commerce. Not only does this affect interstate commerce, it significantly affects interstate commerce, not just as an individual community. If there is ever, God forbid, a school shooting, that impact would go beyond the community and affect other states.
You sound very passionate about this, Mr. Alexander.
Yes, I am very passionate about it. In fact, did you know that 4% of American high school students and 6% of inner city high school students carry a gun at least occasionally? The court did not take into account the reports and cases related to gun school statistics to support the Gun-Free School Zones Act.
What do you think that the court should have focused on?
The court focused on the wrong question. Rather than determining whether the regulated activity sufficiently affected interstate commerce, it should have examined whether Congress could have had a rational basis for concluding it had the authority under the Commerce Clause. If the court would have based its decision on a practical commerce decision rather than a legal one, we would be celebrating the protection of the Gun School Free Zone Act.
Well,
let me just say one thing. I watched your analysis earlier, and gun-related violence near a classroom does pose a serious threat to the economy. It affects educated workers or my staff if there was a gun on campus, and it would affect the communities or businesses who would benefit from the students in each of the classrooms if anything bad were to happen to them due to gun-related violence.
Great points, Mr. Alexander. Very quickly, we're going to check in one last time with our senior legal correspondent, Naomi, who is live at the Supreme Court. Do you have any final comments on Mr. Alexander's opinion?
Oh yes, Jennifer. You know, his comments were very similar to the dissent written by Justice Breyer, with Justice Stevens, Souter, and Ginsburg joining.
Well, thank you for your words, Principal Alexander. We are very happy that you were able to join us today.
Thank you for having me, Jennifer. Also, do you happen to have the number for this Breyer person? I would love to give him a call.
Well, I'll see if I can get that for you. Wouldn't we all love to have the Supreme Court Justices' phone numbers? That's all for today. Thank you for joining me. Tomorrow we'll be interviewing Robert Kardashian about the O.J. Simpson trial. What an interesting name, Kardashian. Good night, everybody.